Hi, my name is Attorney Gregg Wagman. I've been in private practice in Connecticut since 1992. I handle a variety of different of areas of practice, one of being foreclosure defense. I also do a lot of bankruptcy, criminal defense, and personal injury. Today, we're going to talk about foreclosures. What happens if you're behind on your mortgage and your bank is telling you that you're going to be going into foreclosure? Where can you get help with foreclosure? There are several different places you can get help with foreclosures, and we will be going over those here briefly in a few minutes. We'll also talk about what the process is and whether or not you should go into mediation at court. There's mandatory foreclosure mediation since somewhere 2009 or 2010, just after the last crisis we had regarding mortgages. I'll give you some tips about court dates and deciding which type of foreclosure should be your foreclosure if it goes that far, and what happens if you don't move out, and other ways to avoid a foreclosure. So where to get help with a foreclosure? You can go to a foreclosure prevention clinic. These are held usually in each courthouse on a specific date of each month. And if you check with the clerk's office in your district, so each county in Connecticut, there's 8 counties, has its own courthouse for these types for foreclosure cases. And they each have a volunteer clinic once a month normally. So you can call the clerk's office at that courthouse and find out when that is. You can talk to a housing counselor, Connecticut Catholic Charities, the Connecticut Fair Housing, all have different housing counselors that can help you through these things. Talk to a lawyer who does foreclosure defense. There are defenses to these types of things, and there are ways to deal with them. Call the state of Connecticut foreclosure hotline. They will also help you get information regarding how you can help it. Connecticut Housing Finance Authority and Making Home Affordable are also ways to deal with this. If you feel like you've been there's predatory lending, or there's a situation in which you were paying and the bank is saying you haven't been, you may want to talk to the Attorney General's office. Also, be aware of the foreclosure rescue scams. If somebody from California is telling they can help you with a foreclosure in Connecticut, they're lying. You need somebody in Connecticut who knows Connecticut law to help you with a Connecticut foreclosure. Each foreclosure is very state specific. There are foreclosures in other states, and their rules and regs do not apply at all to what happens in Connecticut. In fact, they can really mess you up if you listen to somebody from a different state. Foreclosure, even though the bank says your mortgage is in foreclosure, that just means they sent it to a different part or different department in their bank. The foreclosure actually starts when you are handed papers or they're stuffed in your front door, and that'll be a set of papers called a summons, a complaint, and that will also have a mediation certificate and an appearance form in those paperwork. You have 15 days to fill some of those out and get them back into court. If you don't, you'll be defaulted for failure to appear. An appearance is just a piece of paper that needs to get filed with the clerk's office, and it'll be attached with these papers. But if you don't file that, then the court will go forward and you will get notice of what's happening in court, but you won't have any say in what's happening or how it's happening. If you ignore court paperwork, it will result in a foreclosure eventually. We have required mediation in foreclosure mediation in Connecticut now, and we have had for approximately 10 or 12 years. You can request mediation. A court-appointed mediator will help you work through the process and try and get something worked out with your bank to get you back on track and allow you to keep the house. If you want to move out of your house, you don't want to keep the home, then don't agree to mediation. But a mediator can help the lender or can help you know exactly what the lender is looking for, and so you can possibly work something out with the lender. Do not miss a court date. Missing court dates means the court's going to assume you're not interested enough in keeping the house. And so therefore they will just go forward without you. A judge can give you more time in a foreclosure situation if you have kids in the school and you're trying to make sure they get through the end of the school year, or somebody in your home is disabled. If you can sell or refinance your house and the lender gets their money, the judge, again, will give you some time to do that. But again, you have to let the judge know that you are interested in doing those things and that you need time to do that. There are different types of foreclosures in Connecticut. The first foreclosure is actually you make an agreement with the lender to sell the house. They get their money, you get whatever's left over, and you can sometimes work that out prior to even being in court. If you do it that way, you really need to have just the lender's lien on your house, the mortgage on your house, and no other judgment liens, no other second mortgages or home equity lines of credit. Otherwise, that type of foreclosure doesn't work. Two types of foreclosures will be ordered by a court. One is called a strict foreclosure, and the other is foreclosure by sale. A strict foreclosure will normally be ordered if there's no equity in the property. I mean, the property's value is less than all of the liens added up on the house. So in this situation, if you owed taxes, if you owe any property taxes, that gets added on to whatever you owe them, to the bank or the lender, which gets added on to any judgment liens which are on the property. Judgment liens means somebody sued you and put a lien on your property, try and collect. All those get added up. And if those add up to more than the value of your property, the court will order a strict foreclosure. A strict foreclosure means at the end of the foreclosure process, mediation's done or mediation wasn't requested, then at the end of that process, the court will set a law date. You will no longer own that home after the law date. The bank will own the home after the law date. At some banks will request that the court also order you to be out of the home by that date or just shortly thereafter, and some don't. We'll talk about that more shortly. The other type of foreclosure in Connecticut is a foreclosure by sale, and that's when you'll see signs here and there saying that this house is going for foreclosure sale. You can inspect the house at noon or at 10 o'clock on Saturday, and at noon on Saturday, somebody will do an auction and sell the house. Those are normally done in two situations. One, if looks like there's equity in the home, because the court really wants the homeowner to get whatever equity is available in the home, equity being the difference between what you owe the lender and the value of the home. So if you owe the lender $200,000, but the house is worth $300,000, then you should get that extra $100,000. Normally, if it goes to a foreclosure by sale and it is sold at that sale, that's a lowball price. It's a stressed sale. And so buyers will come in and offer the least amount of money they can. And so that is actually the worst way to sell a house. So you should, if you have equity in your home and you can't keep the home, you really should sell it prior to the foreclosure sale. And a court will give you time as long as you are making efforts to get a sale done. That means hiring a realtor and getting it on the market and getting it sold. The only other circumstance which a foreclosure by sale will be ordered, even if there's no equity in the home, is if the IRS has a lien on the home that they've perfected by putting a lien in the land records. Once they do that, then the house has to go to the foreclosure by sale, even though there will be no equity for anyone to get. The bank can also say, because of the way that when you borrowed money, you told the bank that if you foreclose on me and I still owe you money, then you can come after me for what's called a deficiency judgment. The bank or the lender has 30 days after the judgment, so it's after the strict foreclosure, after the sale, to file a motion for deficiency judgment. Some banks will do that, some banks don't. If they don't file it within the time, they can't come after you later for the amount of difference between what you borrowed and what they actually got when they sold the house. But some banks will do that, and they will then follow up on those deficiency judgments and try to collect the additional money that they're owed after the foreclosure. If you don't move out, if the court orders you to move out in the foreclosure case, then you'll get what's called an ejectment. They basically, the marshal will show up and will tell you you have X number of days to move out, and they will move you out, put your stuff on the street, and then the town has to take your stuff, store it for you, but then you get charged for the storage amount. Or if they don't ask for it in the foreclosure, it'll be an eviction. It's the regular summary process eviction. You will get eviction papers through eviction court. You'll get a notice to quit, and then you will have, get a lawsuit saying that you're not paying the rent, you're not, and you're there beyond, there's no lease involved. And so they will ask the court for a specific eviction date and ask you to move out. Again, do not ignore these papers, because it can buy you some time. If you're still in the house and need some time to move, you can usually get a little extra time to help that. If you don't move out and there are people living there who are 18 years of age or older and their names are not on the lease of papers, it's only going to affect those people who actually get named in the eviction. And sometimes that type of thing can buy you some more time. So other ways to avoid foreclosure, if you have mortgage insurance. So it's sort of in a situation where you got sick or you got hurt and you can't work anymore, so you missed some payments. If you have mortgage insurance in place, then that can help you avoid the foreclosure. If you sell the property, then that will avoid the foreclosure. But again, you won't own the property anymore, but it can pay off what the lender is owed. Foreclosure cancellation, rare, but sometimes happens if the bank does not have their paperwork properly done. Satisfaction on the judgment. So if it goes to a judgment, a strict foreclosure or foreclosure by sale, and you come up with the amount of money that's needed, then you can stop the foreclosure. So that's basically usually a refinance. You can ask for an extension on the time, and the judge can grant that if they feel the reasons are good enough. But again, remember, a judge has to balance the rights of the creditor, the bank, and you, the homeowner. Actually, one of the most powerful ways to stop foreclosure is bankruptcy. There are two types of bankruptcies, two types of bankruptcy options. Both of them stop the foreclosure on the date and time that the bankruptcy is filed. So one's a Chapter 7, the other's a Chapter 13. Chapter 7 we call a fresh start. So the basic idea of a Chapter 7 is it would take care of all your other debts and then maybe allow you enough money, enough breathing room in your budget to be able to get into mediation and get back on track with the mortgage itself. If there are judgment liens on your home, then sometimes in the right circumstances, those judgment liens could be stripped off the home, giving you the ability to sell the house and or refinance the house, or get some sort of mortgage modification, which allows you to keep the home. Chapter 7 will only give you at most breathing room of 4 to 6 months at most. It can be shorter depending on how the bank reacts to you filing bankruptcy. A Chapter 13 allows you to catch up on the mortgage. So if you're behind because you're out of work for a while, but now you're back to work, in order to be in a Chapter 13, you have to have a source of income, and you have to be able to show the bankruptcy judge that you're going to have enough money to pay not only the mortgage and keep it current during a 3 to 5 year process, or you have enough money to pay the mortgage, keep it current, and have enough money to catch up on whatever the arrearage is, the amount you still owe the lender, and pay the rest of your bills. And that's called a Chapter 13 plan. If you can convince the bankruptcy judge that you have enough money to do that, so that's normally a situation where you're out of work for a bit of time, but you're back to work. A Chapter 13 judge will look upon that situation very sympathetically. And at that point, the judge will tell the lender how much they're going to get over the next 3 to 5 years to allow you to catch up. And they, in turn, are not allowed to continue the foreclosure. And as long as you're making the payments to the Chapter 13 and you're making your mortgage payments on time, keeping those current, you'll be allowed to keep the home. Again, these are just kind of touch base quickly on these types of solutions. However, if you really, in this situation where there's a foreclosure on the line, you really need to see a bankruptcy attorney at that point. Learn your options quickly. Just come on in and, you can always do one free consultation, 30 minutes to let you know what your options are. I do a quick intake to find out what your current situation is in. And then we talk about what would work for you and what wouldn't work for you. So if you wish to do that, just give us a call at 860-444-0100.